In this specific podcast, we're going to consider the types of orders that a court can make. We'll look at the relationship between spousal maintenance and property settlement briefly. We have already done that last week. We'll consider issues of conduct during the relationship. So what's the impact of things like family violence, reckless spending, non-disclosure of information, assets, financial resources, documents. And we'll also consider consent orders and binding financial agreements. And then in the second podcast, we'll consider the powers that the court has in relation to third-party interests, and we'll also just briefly touch on injunctions. So that's our plan of attack for this module. Okay, so the orders that the court can make are set out in Section 80 of the Family Law Act for married couples and Section 90 capital S for de factos. So have a look at these sections. You should have already looked certainly at Section 80. There's a variety of orders that the court can make in relation to property. So the court can make an order for the payment of a lump sum, for example, whether it be in one amount or by instalments. They can order payment of a weekly, monthly, yearly or other periodic sum. You'll see when you look at Section 80, they can also transfer or settle property, and that can be done by way of maintenance for a party to a marriage. The court can appoint or remove trustees, make an order by consent, which we'll look at today, impose terms, conditions, so really broad powers when it comes to the types of orders that can be made in relation to property. So we've already spoken about the relationship between spousal maintenance and property settlement in the last module. And regarding Stanford, remember the High Court case, we know that the ability for the court to make property settlement orders doesn't automatically require the court to do so every time an application is made by parties. So sometimes it will be the case that it's more appropriate for the court to make an order for spousal maintenance only. And that was discussed in Stanford, you'll recall. So property settlement adjustment orders may or may not be made at all. So it's important to have an understanding of why one might be more appropriate than the other. So property orders are intended to be final and in line with the clean break principle, so a once and for all order. But spousal maintenance orders are always able to be varied in the future, and we've discussed this in the previous two modules. So generally speaking, you would prefer to do a lump sum property settlement order compared to a periodic spousal maintenance order, because a spousal maintenance order can always, say, increase through a variation of the order depending on the circumstances. Let's now look at conduct that can impact on the orders that a court will make when adjusting property interests. So there are circumstances where if one party has been violent towards the other throughout the course of the relationship, and that is violence in the context of family violence, there is an ability for the court to take this into account when dividing property. So the leading case on this is Kennan, which is up on your PowerPoint. If, for example, during the course of a relationship that, say, spans 20 years, the husband physically abuses the wife, constantly belittles her and berates her, damages property, and generally makes her life quite difficult, then there is an argument that her contributions were made all the more onerous in terms of her maintaining the home, looking after the children, doing chores around the house, and that was made more onerous by the husband's conduct. So arguably, she can receive a larger percentage adjustment on contributions. So have a look at the case of Kenan. It's one of your prescribed cases, and I have also listed a few others on this point on the PowerPoint for you. What about drug addictions? So Farmer and Bramley, you may recall, was a situation where there was a lotto win, and the husband had a heroin addiction that the wife had nursed him through. And the court made certain findings about the contributions that the wife had made to the drug addict husband's acquisition of property, including the lotto win. And there was a successful argument in that case that the wife should receive a greater entitlement to the pool of property than she would have otherwise have received if the husband had not been a drug addict. You can compare Farmer and Bramley with Whiteley, which you may recall was the case about the Australian artist and his muse. And in that case, both parties were using illicit substances throughout the course of their marriage. Now, it wasn't taken into consideration by the court on the facts because neither party suggested that it made things any more difficult for them. What about deliberate or reckless or wanton spending? And this is one of the more controversial ones that tends to come up in practice. So one party, for example, may be saying, look, the other party's gambled in excess of, $1,000 per week for the last 10 years we were together, and I believe that this was reckless behaviour and conduct, and, she has really had all that she should be entitled to because of the fact that she's blown so much money on, say, the pokies or gambling at the casino. There is an ability to argue in property settlement adjustment cases that someone's conduct constitutes reckless dealing with property or failing to, say, maintain a home. In circumstances where someone has deliberately tried to reduce the value of the asset pool available for distribution, or where they devalue items of property, these matters can be taken into account by the court. It is a hard argument to run in terms of an add-back argument. So, for example, that if she spent $1,000 per week on gambling over a 10-year period, it's hard to argue that all of that should be added back onto the other party's entitlement. Although in some circumstances the court may order the monies be notionally added back into a pool, although it is less the case that will occur. Kowali, I always have trouble pronouncing that, is the case on this point, which is in your module outline. Now, non-disclosure, the last point on your PowerPoint, is all about what we talked about in the last module when we looked at the pre-action procedures and that duty to disclose assets, income, liabilities and financial resources. Recall that these details are to be provided in the financial statement, and if, for example, a party failed to disclose and there was an extra bank account with $100,000 sitting offshore or in a different account and the other party didn't know about it, if it came to light that they had failed to disclose that, the court has the ability to make adverse findings. So, for example, there are cost consequences because they've been non-compliant with their obligations under the family law rules. And as I said earlier, property settlement orders are intended to be final, but if it comes to light that there's been non-disclosure, then the order potentially has the ability to be revisited and the case reopened. Now, this slide just elaborates on the domestic violence argument. for it to have an impact on how the court determines the parties' contributions when looking at Section 79. And in the case of Kennan, the court said, so I'll just read this from the PowerPoint for you, where there is a course of violent conduct by one party towards the other during the marriage, which is demonstrated to have had a significant adverse impact upon that party's contributions to the marriage, or put the other way, to have made his or her contributions significantly more arduous than they ought to have been, that is a case which a trial judge is entitled to take into account in assessing the parties' respective contributions within Section 79. So the text on your PowerPoint that I've just put in bold are the things that you need to establish. So there has to be a course of violence that is demonstrated as having a significant adverse impact on the parties' contributions. So you have to prove that adverse impact on the other person. And this is taken into consideration when you're looking at the parties' respective contributions under Section 79 subsection 4. So not at the Section 75 subsection 2 future needs factor stage. This conduct is factored in at Section 79 subsection 4. Now in Oliver and Gall, a more recent case, so 2008, the court said, numerous allegations are made that are not tied in any way to an inability to contribute, or that the wife's contributions were made more arduous. So there is no attempt to quantify the effect of the husband's conduct upon the wife's capacity to make contributions. So in this case, the Kennan argument wasn't effective because the link between the conduct of the party committing the abuse and the adverse effect wasn't able to be established. So that proof element is incredibly important, and the Kennan argument will fall down if it's not satisfied. So one of the federal magistrates of the Federal Circuit Court, so Federal Magistrate Michael Jarrett, who's now a judge, I believe, has written a great paper which I will post on Blackboard for you. Have a look specifically at page 11, where the process for establishing the Kennan argument is explained, and I've put some of the points up on your PowerPoint here for you. So what about negative contributions? So negative contributions is the economic misconduct that I was talking about earlier, which results in the reduction of assets available in the property pool. And I put a case on the PowerPoint for you, which is on point for this matter. So if you're struggling to find some of the cases, remember that the FLC citations are available on the CCH database. So it's important that you're familiar with that database. So the different financial losses that are incurred during a relationship are usually shared and it's considered that that's appropriate. It's similar to a partnership in that one party is responsible for the other party's debts as well. But arguably, there are some circumstances where it can be dealt with differently. And it has to do with negative contributions and conduct of one of the parties. So in some circumstances, the court will not share the financial losses equally between the parties. So where one of the parties has embarked upon a course of conduct designed to minimise or reduce the effective value or worth of matrimonial assets, the court can make an order that in effect means that one party bears more of the financial losses than the other. And another example is where one party has acted recklessly, negligently or wantonly with matrimonial assets, and the overall effect is that the assets have been reduced or the value minimised. As I said earlier, if a party fails to provide full disclosure, then the court does not need to be overly cautious in making findings in favour of the innocent party who has fully disclosed. So a lack of full disclosure means that the court's orders can go beyond the identified property. And what I mean by this is, say if the court is aware of an asset pool that consists of, say, 500,000 of non-superannuation assets and 200,000 of superannuation assets, the court can act on the basis that there's more in the pool than that, even if you don't exactly know how much more. So effectively the court can say, even though the effect of the order being made is that 100% of both pools will go to the innocent disclosing party, we think that the person who's failed to disclose has a substantial asset available to them, and we're taking that into account in exercising discretion to make an order considered just and equitable. So the court doesn't need to know the exact value of that asset that hasn't been properly disclosed to make that kind of finding. Now there are a couple of different ways that people resolve property matters by agreement. So whether it's informal or formal, people will go about this how they see fit, really. So if people take an informal agreement approach, it's simply because they don't want lawyers involved at all, and they want control over their own terms of agreement. But the problem in practice with this approach is that it's neither final or enforceable. It gives the parties financial privacy, but you can't rely upon it down the track. And the difficulty can be that you could find yourself in a position where the matter is entirely reopened before the court. So for example, remember in the case of Bevan, which we talked about last week, where the husband had made representations to the wife over a long period of time. They had an informal arrangement / agreement that everything in Australia was the wife's, and this was ultimately upheld, wasn't it, before the court. And there was no property settlement orders made. But because they hadn't formally divorced, the time limitation period hadn't started ticking, and there was no enforceable order which protected the wife. They only had an informal agreement, didn't they? But remember that this case was unique in that a period of 18 years had gone by. So if you have a situation where the time period between the private agreement between the parties and then, a shorter time lapses and one party reneges on that private agreement and commences proceedings, then the court can intervene and, the private agreement is of course then totally unenforceable. So you need, in practice, to advise your clients that they can't rely on an informal agreement. So the benefit of consent orders is that they can be done without solicitors, they're flexible, they're enforceable, and you can deal with both parenting issues and property in the one document. It does reduce legal costs if the parties can reach an agreement and simply formalise it by lodging it with the court, which is what a consent order is about, of course. So it can be dealt with by a registrar in their chambers. so the parties don't even need to go to court physically. So it's just a matter of lodging the paperwork with the court registry, and a registrar is basically a lawyer employed by the court who has delegated powers of a judge to make the orders in chambers if they consider the orders to be just and equitable. So they will still examine the orders and determine if they're just and equitable. So it's not an automatic order. The reason that I've put on the PowerPoint that consent orders are a comfort zone for solicitors is that BFAs, which are binding financial agreements, are quite notorious, and you've all heard of the term prenups, and we'll talk about them in a second. So they're notorious for being set aside and not being upheld. It is difficult for a solicitor to be able to tell their client with confidence that a binding financial agreement will actually be held up in the future. And they're quite expensive to have drawn up. So courts do set aside BFAs on the basis of technical difficulties within the documents and non-compliance with the legislation, which we will, as I said, talk about in a moment. Here with consent orders, you have a document which is being approved and stamped by the court, and a registrar is finding that that order is just and equitable. So they really are, consent orders really are a comfort zone for solicitors. The power for a court to approve a consent order is found within Section 80, so within that list of the types of orders that a court can make. And they are still made under the power of Section 79, and you are making an application for consent orders, and both parties will sign the order and lodge it with the court. Now, Section 79, capital A, does enable orders to be set aside, whether they're made by consent or after a contested hearing. There are a variety of different bases for which a consent order can be set aside. And have a look at Section 79, capital A. It is more broad than consent orders. You'll see that when you have a look at it. It provides a basis for the setting aside of orders altering property interests. Okay, so binding financial agreements, BFAs, have been around since 2000. And you need to have a look at Part 8, capital A, which provides for parties to be able to deal with financial matters outside of the court. You don't register the documents, the BFA, with the court, but you can, so they're different to consent orders in that respect, but you can rely on them if they're being prepared correctly, and you can enforce them through court mechanisms. Effectively, the benefit for some parties with these BFAs is that you have privacy of your financial affairs, and you can exclude the jurisdiction of the court to be able to make a spousal maintenance order and a property settlement order as long as the agreement remains in force and is upheld. So a binding financial agreement can be entered into in a number of different circumstances, and I've put the relevant sections and times up on this PowerPoint for you. So you need to go and have a read of these sections. No matter, so it can be entered into prior to marriage or cohabitation, during the marriage or during the cohabitation period, or afterwards. So no matter when it's entered into, regardless of whether it is prior to the relationship, during the relationship, or after, one common dynamic is that people prepare the document and then they tend to forget about it and don't revisit it and change it as their circumstances change. And this is one of the issues with BFAs that are entered into, prior to the separation period. They may have been just and equitable when they were entered into, but circumstances can of course change, and they may no longer be just and equitable when the time comes to enforce them. You know, people's job situations may change, children may be born, one party may give up a job and to look after the other party or to look after children. So you could also have a situation where there's a technical problem with the document and the lawyer who thought that it was compliant with the legislation had actually made a mistake and it isn't, which makes it difficult for it to be enforceable. There were some substantial changes really since 2010. I'm not going to go into these, but just essentially the changes were about making it easier for lawyers advising clients and drawing up these documents to comply with the legislative requirements. The requirements for a BFA to be binding today are that they must be signed by all parties. Before signing, each party has to be provided with independent legal advice, and each party must be given a signed statement stating that the advice was provided. A copy of that statement must be provided to the other party, so there's the exchange of those statements. When it comes to enforcing the agreement, the court must still be satisfied that it would be unjust and inequitable if the agreement was not binding on the spouse parties. And because of the changes in 2010, future claims against practitioners are less likely. Now, the reason why people also prefer these kind of agreements relates to spousal maintenance. With spousal maintenance, if you have a property adjustment dealt with by the court, or if you file a consent order for property, but you leave out spousal maintenance, then arguably one party still has the ability to make a later application for spousal maintenance, as long as it's not done out of time. But recall that you can be granted leave to apply outside of time in certain circumstances for a spousal maintenance order. A BFA can specify that a party cannot apply for spousal maintenance in the future. So effectively, if you were to negotiate with your spouse at the time of separation that they can have, say, 85% of the pool of property on the basis that they'll never apply for spousal maintenance, then as long as the binding financial agreement is binding and complies with the required technicalities, then you have finality, and it provides, of course, then also financial securities, financial certainty for the parties moving forward. If you're putting an arrangement regarding spousal maintenance into a BFA, then there are specific requirements that the parties need to be able to show were complied with to enable that finality to be effective. So if the BFA excludes the court's jurisdiction regarding spousal maintenance, then certain things need to be included within the BFA. And one of these requirements is that the party who is foregoing their right to apply for spousal maintenance must not have been in a situation where they were unable, or they've been unable to support themselves without an income-tested pension allowance or benefit. Now, whether or not this is the case is assessed at the time that the agreement comes into effect. So if you're putting this BFA into place pre or during the relationship, then it may be void if upon separation the party who did away with their ability to apply for spousal maintenance is in need of a benefit. Now, superannuation can go into BFAs as well. regardless of whether or not the superannuation is in existence at the time of making the binding financial agreement. So in other words, a BFA can include future property too. Now, a BFA is of course a contract, so it needs to comply with the requirements of contract law. It continues if one party dies, so it can be enforced by or against a party's estate. What about setting aside a BFA? So there are circumstances set out in section 90 capital K, which include if there has been fraud by a party or an intention to defeat a creditor. So for example, if one party is going bankrupt, a BFA can't be utilised to defeat any creditor's claims. There are some others as well, unconscionable conduct, or if it's impractical to carry out and apply the BFA. So an example of a BFA being impractical is if a BFA says the couple agrees that upon separation they will transfer the property into say a piece of real estate, a home, into the husband's name from being in joint names, and the husband will refinance the mortgage and pay the wife a certain sum. So say if the BFA provides for that, if the husband couldn't, despite his best efforts, refinance, and there was nothing else in the BFA providing for what to do if this happens, for example, that the house would be sold, then clearly this BFA would be impractical to carry out. Okay, the two sections on this PowerPoint provide for the enforcement of BFAs. These provisions simply say that a BFA can be enforced as if it's an order of the court, as long as it's compliant with the legislation and binding for the purposes of the Act. Okay, that's the end of the first podcast. So in the next podcast we look at superannuation and also third parties. So when you're ready, please move on to the second podcast.